And that's where the WCAG standard got hung up on issues of implementation. How long should companies have to implement? What should be the penalties for failure to implement? Should there be any grandfathering? So there were a whole host of issues that never got resolved that, again, we're now dealing with on the back end through these lawsuits. So how do you protect yourself against another lawsuit? Understand your technology, understand the architecture of your website. What we encourage our clients to do is to triage their website. To me, there's a big difference between the picture of the daffodil and the drop-down box. When you go to book an airline ticket, you have to go through a series of drop-down boxes. Those are the critical access points. The picture of the daffodil, not so much. Will you agree as part of your remediation to say this is a picture of a daffodil so that a blind user understands that? Yeah, you will. But your real focus should be on where are the problem areas. Do your drop-down boxes provide access to people so they understand what they are buying, what their options are, etc. One of the issues that we had in the government case was that for me to get online, I am not visually impaired. It takes me virtually no time to zip through an airline website to purchase a plane ticket. For someone who relies on a screen reader, it's going to take considerably longer. What was happening with the government's website? It was timing out after 2 minutes. Well, if you're sighted, 2 minutes to go through a web page, that could be 3, 4, 5 times the amount of time that it should take. So timing out after a couple of minutes doesn't seem like a big deal. But if you are blind or visually impaired and are relying on a screen reader who has to read to you the drop-down boxes, 2 minutes is an insufficient amount of time. So there are adjustments like that that have to be made to accommodate the needs of the blind and visually impaired. There are other kind of what I consider low-hanging fruit of items that can be remedied to ensure that your website provides effective communication to the blind and visually impaired. I'll just say this, and I'll turn it back to Jason, but I view this like the two campers who encounter the bear. The one turns to the other and says, I can't outrun the bear. And the other camper says, I don't have to outrun the bear. I just have to outrun you. And what we want here is for your companies not to be the ones that are easy targets. If you can make certain just basic changes to your websites, you outrun the other guy and you make the other company, the lower hanging fruit, the easier target.
Lewis, that's great. And we actually just brought up a slide here which sort of takes you through some practical stuff. I also want to say that we're going to deliver with the follow-up to this webinar an email with 3 or 4 free resources which any company can start using to sort of get to that place which Lewis talks about, which is a safer place. There are ways that plaintiff lawyers are looking for websites. The first thing they're going to do is they're going to run from some free tools that test for WCAG 2.0 and see whether there's lots of issues. So we actually have a free service that you can do that with, and you can see where you're at. So the first thing that I would say practically is on all of the major web pages and user flows that you have, make sure that you're as clean as possible using those automatic tools. That's going to drop you down with regard to the lower hanging fruit that Lewis talks about. It also will practically improve the accessibility of your site. A very important aspect on that front as well, which I think a lot of the times people may miss out, is 95% of websites today were purchased off of somebody. You paid a web designer to build it. You paid an agency to build it. First call is call the company that knows about websites and find out what have they done about web accessibility, how can they help you around web accessibility, what's their position in terms of making sure that the next website they build is accessible. So thinking about adding into contracts, adding into renewals, but you put the responsibility of web accessibility onto your agency. The second thing that I know Lewis might have an opinion about is that we strongly recommend that whatever your plan is, you tell people about. Again, if you've got a good accessibility statement, and we wrote a blog about this, where it talks about we're doing this, we're working with these companies, this is our commitment. It's another thing that a plaintiff lawyer looks at and thinks, do I really want to sue a company that's already on the front foot? I really want to go after companies that are on the back foot, because the first conversation is a negotiation. If you're on your front foot and you're very proactive about what you're doing, that puts the company in a better negotiation with a lawyer. They try and avoid going after companies which are on the front foot. Something to Lewis's point, train support staff on looking out for people calling, know how to escalate if someone with an assistive device has a problem, making sure that it's part of formal training with regard to online support. I think is very important, because it's also something you can make a point about. It's about accommodating. It's about, again, being on the front foot. We would also encourage you engage in a group of people who have disabilities, whether that's employees, relatives of employees, reaching out to clients that potentially have disabilities, reaching out to local non-profit organizations. There's many ways to do this on a very affordable basis. And then I'd always look to invest in creating an expert that's going to know this subject matter. Now, of course, you can hire, but you can also train someone internally. It doesn't have to be external if you're a small organization. It's making sure that you've got someone who knows this subject quite well internally. And again, really just saying to Lewis's point, be one of the companies that don't come up when they test 100 sites. You test quite well. You've got a great statement. You're on the front foot. This will protect you more than any secondary sort of legal advice that you're going to get. Being proactive, I think, is going to put you in the best possible position. I don't know if you had anything to add on that, Lewis.
Just that from the practical perspective, Google WCAG 2.0, and you'll see the standard, and included among the standards, have an accessibility statement on your website, and they're not difficult to draft. We draft them all the time for clients. We do. Some want a generic one, some they want a more bespoke, customized accessibility statement that reflects their company's values. We've done both, but that's the low-hanging fruit, that you can just include an accessibility statement. Our goal is to provide, effective communication to all users. Again, most companies that are customer-facing, they want to be customer-friendly. They want to let all of their customers, disabled and non, know that their goal is to provide a positive customer interface experience. Have a feedback loop. Say, in your web accessibility statement at the end, if you're having trouble with our website, contact us. Here's a phone number, here's an email address, here's a place where you can leave a comment. But again, just something that says to your community, we care about you and we're invested in you. Very briefly, what can we expect? There was a case that a petition for cert was filed with the U.S. Supreme Court, and the petition for cert was denied. That was the Robles v. Domino's Pizza case out of the Ninth Circuit, California. And there was something that was very interesting about the Robles case, and that is that at the district court, the trial court level, Domino's defended by saying, hey, look, we have an 800 number up on our website. Anyone that wants to call can basically get the same goods and services as someone who can access Domino's.com. And the trial court agreed with them and said, yeah, that is effective communication. And the Ninth Circuit, the Court of Appeals, reversed and said, it's not that an 800 number does not provide effective communication. It's that, and it gets back to that dichotomy I discussed at the very beginning, it's the difference between being able to dismiss a case as a matter of law versus finding that there are no material issues of fact. And what the court basically said is the 800 number alone, just telling us you have an 800 number, does not tell us that you provide effective communication, because it doesn't tell us whether it's available 24/7. It doesn't tell us whether, you can order a pizza on the phone contemporaneous with the store openings. There are a lot of questions about that. But keep that in the back of your mind, that having an 800 number is just, again, one of those items that kind of fall to the low-hanging fruit category. Having that and letting your community know that there is a way for them to contact you if they're having problems, if they want to access something that otherwise might not be available on the web, is something that I would encourage you to consider. The other thing that we are seeing now in 2019 that I suspect will continue in earnest into 2020 are gift cards. Recent spate of lawsuits, last count there were over 200 of them, filed against retailers claiming that the failure to have Braille available gift cards violates the ADA. The genesis of this case, and I learned this from plaintiff's counsel himself, is he went to a Starbucks, and Starbucks actually makes a certain number of gift cards available in Braille. And he then went to Target, and he looked at the rack of gift cards, and other than Starbucks, none of them had Braille, and he just started filing lawsuits. And those lawsuits are following the same general trend as the website lawsuits. They're settling on an individual basis. Plaintiff's counsel is demanding some form of injunctive relief. He is being very flexible in terms of the injunctive relief. So, for example, not every gift card has to be in Braille. You can have a certain number or percentage of them in Braille available on demand or on request. You can also make gift cards available electronically. And I think we're going to see more and more lawsuits filed against, again, we're seeing it in the gift card area. I think you're going to start seeing them in the food and beverage area. The indication of calories and other types of information that's on food packaging. There are defenses to these cases, but for most companies, they don't want to be seen as the company that was opposing implementing an accommodation for the disabled, for the blind, for the visually impaired. And that's where kind of corporate image and the law hit head-to-head, where to say to a company, yes, you could defend this, but what's that going to do to your corporate image? And do you want to be known as, again, Robles v. Domino's? Like, does Domino's want to be known as the company that didn't want to make an accommodation for the blind? No. And in fact, they did make accommodations for the blind. But again, their name is associated with this lawsuit that just went up to the Supreme Court. Very few companies are willing to put their corporate image on the line. And that's something to consider in this whole ball of wax. I know there are a number of questions that have been posed, so let's get started.
Great. So first question, if your website is accessible, do you also need to make a phone app accessible as well?
That's one of the trends that we expect to see in 2020 in that. And Jason, I think you've had experience with the apps.
Well, yeah, I mean, we already see that there's an increase of lawsuits around mobile apps, I think for two reasons. The main reason is apps are fundamentally important to everybody. If they're not accessible, clearly there's going to be a groundswell of, well, I can't use apps and everyone else is using apps. So I think it's just as important as website access. And second, court cases such as Domino's list apps as part of the target. So of course it creates an opportunity for plaintiff lawyers.
Okay, someone is seeking clarification. Louis, did you say that showing progress towards remediation after a lawsuit doesn't help in future lawsuits if another is started after the first?
The remediation is not yet complete, and even if it is, if it relates back to inaccessibility prior to the remediation, the 11th Circuit has said that's fodder for another lawsuit. That plaintiff does not lack standing because of subsequent remedial measure. They may still have been damaged or harmed. The problem they're going to have is the remedy that they would seek under the ADA has already been effectuated. They would therefore have to bring some type of claim under a baby mini state ADA claim showing that they were actually damaged. It's not the highest hurdle, but it's also not the lowest rung on the ladder. Repeat cases that I'm seeing are ones where the remediation is not yet complete. I've not had one yet where the remediation is fully complete and the lawsuit's then filed after the fact. The problem that you run into is just one of cost and efficiency. I'll make up numbers, but if someone's willing to walk away from a lawsuit for $5,000, and you could say, look, you know, we've remediated, and they say, well, I'm willing to walk away for $5,000, $10,000, when you know the cost of litigating that to get them to go away could be that and more. It's difficult for companies to, you know, they'll hold their nose, they'll stamp their feet, and it stinks to high heaven, but that's the blackmail, and they'll say, you know what, I just want to pay this guy and have him crawl back under a rock and just be done with this.
Okay, and what about people or companies who may be using WordPress or other such web page creators where they don't have access to basic code?
I think from a legal perspective, they're not protected because they're using a third party. They're meant to be responsible for what they are providing. But I do see a trend in 2020 where CMS companies, they'll launch a whole range of accessible templates, meaning if you use these particular templates and you don't change them, we've made sure that they're accessible, and there's a lot less chance that you can create inaccessible content, because practically it doesn't make sense that an art gallery pays $50 a month for a CMS website that they can get a $10,000 lawsuit for using. Again, I think there's going to be a very strong swing because of lawsuits towards where are these actual websites coming from? Are they CMS systems? Are they design agencies? Are they platforms? Technically, these companies need to solve this problem for their client, because those clients are not going to stay with them if they keep getting lawsuits. So I see that the technical side, for the simpler sites which are based on CMS platforms will start addressing this as part of their offerings to clients.
I saw a question I've got to answer. Does this apply to law firms? And yeah, I'll tell you that when we first started defending these cases, one of the first things we did was have someone look at our website and make sure that we were ADA compliant. The answer is yes and no. There are some law firm websites that you can process your payment online using a credit card. I would say that you know, it's more likely than not that type of website would be considered a place of public accommodation. Other legal websites that really just provide bios, etc., you know, I think it's a closer call. Interestingly, the lead plaintiff's counsel who's behind most of these lawsuits is a guy named Jeff Gottlieb out of New York. And Jeff has a website. I happened over the weekend to take a look at Jeff's website, and more importantly, because he just put the website up a couple of weeks ago, he has a web accessibility statement. And it's interesting because his web accessibility statement says, we strive to comply with WCAG 2.0, but don't in all cases. You know, it's interesting that the main protagonist here readily acknowledges that his website, while he maintains it does provide effective communication, isn't wholly ADA WCAG 2.0 compliant.